The duo, in their appeals, prayed the Apex Court to set aside the judgment of the Presidential Election Petition Court, PPC, which affirmed Tinubu of the ruling All Progressives Congress, APC, as the valid winner of the presidential election held on February 25. Whereas Atiku, through his consortium of 67 lawyers that comprised 18 senior advocates of Nigeria led by Chief Chris Uche, filed 35 grounds of appeal to challenge Tinubu's election victory. Obi, through his own team of lawyers led by Dr. Levi Uzuku, SAN, filed 51 grounds of appeal before the Supreme Court. Specifically, Atiku, in his appeal, maintained that the verdict of the Justice Haruna Tamani-led 5-member panel of the Court of Appeal, which had on September 6 dismissed his petition against the outcome of the presidential election, was not only against the weight of evidence, but occasioned a grave miscarriage of justice against him. The former vice president insisted that the PPC panel erred in law when it failed to nullify the presidential election on the grounds of non-compliance with the Electoral Act 2022, even when evidence that was adduced before it showed that the Independent National Electoral Commission, INEC, acted in breach of extant laws and regulations guiding the conduct of elections. He accused the PPC of reaching its unanimous decision based on gross misconstruction and misrepresentation of provisions of both the 1999 Constitution, as amended, and the Electoral Act 2022. According to him, the lower court erred in law when it refused to uphold the mandatoriness of electronic transmission of results for confirmation and verification of final results introduced by the Electoral Act 2022 for transparency and integrity of results in accordance with the principles of the Act. He argued that Section 64(4) and 5 of the Electoral Act, as well as INEC's regulations and guidelines for the conduct of the election, which he tendered in evidence, made mandatory the use of the Bimodal Voter Accreditation System, BVS, machines for electronic transmission of results of the election directly from the polling units to INEC's collation system for the verification, confirmation and collation of results before announcement. Atiku told the Apex Court that some of the presiding officers that personally handled the BVS machines at polling units on the election day had in their testimony before the PPC confirmed the non-transmission of results of the presidential election electronically from the BVS machines, whereas results of the National Assembly election that held simultaneously were electronically transmitted without difficulty. More so, he told the court that INEC's sole witness, Lawrence Bayod, admitted that the commission experienced a technical glitch that made the system to fail to work on the day of the election, which technical glitch was not explained by the first respondent. Besides, he argued that by virtue of Section 169(1) of the Constitution and Section 148 of the Electoral Act, the INEC regulations and guidelines had the force of law, being a direct product of the Constitution itself, thus qualifying as a subsidiary legislation. Atiku told the Apex Court that the non-compliance with the Electoral Act was nationwide, cutting across 176,846 polling units in the country, a situation he said substantially affected the outcome of the election. The case of the appellant was that under the new legal regime of technology-based collation of results under the Electoral Act 2022, the appellants, by credible evidence, established deliberate non-compliance by the first respondent with the electronic transmission of election results, which was nationwide. He said the outcome of the election ought to have been cancelled based on the doctrine of legitimate expectation. On constitutional requirement of 1/4 of the votes in 2/3 of the states and the FCT, Abuja, Atiku argued that it was an additional and mandatory requirement to the provisions relating to the highest lawful votes and therefore a condition precedent to a declaration by INEC.